the political will existed in the early 1890s, around the time of the Panic of 1893, to take some steps to improve the basic situation of workers on the ground. The Sherman Antitrust Act was passed, an income tax which had been used to fund the Civil War, but then canceled, and tariffs were used to fund the federal government, came to be viewed as regressive. The tariffs came to be viewed as regressive because essentially the same premium was paid for poor people and rich people if tariffs are being applied to basic goods. So there was an income tax that was passed. Then later on, you started to see states legislating for health and safety in situations where immigrant workers were in terrible industrial situations with, machines chopping off people's hands, and mill owners requiring people to work 7 days a week and things like that. But the Supreme Court, for ideological reasons that really seemed very loosely tied to the Constitution, took steps to curb these actions. They declared the Sherman Antitrust Act unconstitutional in the E.C. Knight case. It did start to back off of that after 5 or 10 years, but it took about 20 years to sort of clear the way for antitrust prosecution. The Pollock case was a disaster because it required a constitutional amendment to overturn it, and for 18 years, there was no income tax and a lot of anger in the country about the way that the government was funded. The Lochner case, which invented sort of a right of contract as a way of preventing labor regulations, was used to prevent things like minimum wages at a time when people were really, really hurting. Harlan dissented in all of those cases along with the race cases, and he did so in his own sort of inimitable, forceful style.
A very charitable reading of Chief Justice Taney's opinion, or his motivations, was that he was hoping to settle the matter of slavery, as President Buchanan would say, settle the matter for the country and move along. Clearly that backfired, and I think that the humility that Justice Curtis showed, the rest of the justices would have been well served to show that same humility. And many people are familiar with Curtis's dissent, but not many people know that he resigned shortly after. And I think he's the only justice in history to resign in protest. And so what happened was he gave his dissent to a newspaper to publish it. And he says he thought that Chief Justice Taney had already, allowed the publication of his opinion. Whether or not that's true, we don't need to get into, but Chief Justice Taney was not pleased, and he set about revising his opinion to try to address more of Curtis's points. And he tells the clerk of the court not to allow Curtis access to the revised opinion. And there's this frosty exchange of letters. Taney accuses Curtis of not being gentlemanly, the horror, and of requesting the opinion for partisan and political purposes. Curtis says he's entitled to see it, and the public is entitled to see this opinion. And ultimately, it was, of course, eventually published. All of them were, and everyone could see the shallow sophistry, as one contemporary newspaper called the Chief Justice's opinion. But this led Justice Curtis to resign just a few months later, and he cited his lack of confidence in the court and a lack of willingness among the justices to cooperate. And you have to wonder if our country would have been better served if Benjamin Curtis would have remained on the Supreme Court longer.
Like Washington, he was the guy who, Washington was the guy who made the decisions on how it would be to be president. Everybody said, "Oh, okay, this is the way we're going to do it." Marshall was a persuasive guy. He was a guy who had been around. He had been a diplomat even in Europe. So I think he had a diverse background and a willingness to compromise within his court system. He didn't want to compromise, as Elizabeth said, in this idea of unanimity, because the Supreme Court did have it was the third of three, until he came about. And for I don't know how you can say who's more important or not, but it certainly gave the Supreme Court legitimacy, and that was his big goal, I think.